All right, folks. Well, I'm going to get going, and I think we might have some folks join us as we go. My name is Angela Colaiuta. I'm a public defender. I believe that the system isn't broken, it was built, and it's my job to stand in the way of that system and stand up for my clients. I created this training because narrative distortion is one of the system's most effective weapons. The story the system tells about itself, who deserves grace, who's presumed guilty, whose expertise is treated as gospel, and whose advocacy is cast as a problem. Bullshit thrives in the gap between assumed credibility and unexamined conclusions. When we don't name it and resist it, the gap widens. The system's narrative are engineered to sound obvious, inevitable, authoritative. That design only works when its assumptions go unchallenged. This training is designed to help to give you the tools to challenge it. So first, a few little housekeeping matters. There is a handout, so there's no need to take notes if that is your jam and you want to take notes. By all means, I'm not trying to stop you. I just want to let you know that this will be in the handout. We've applied for 1 hour of CLE credit through the Washington State Bar Association. We've not yet been approved, but we will report that credit for you. We have put up on the screen there the activity ID. And we ask you that if you're unable to stay with us for the full hour, that you be responsible for reporting whatever portion of the hour you are able to be here. Another note for you, this will be interactive. I will be asking for you guys to respond in the chat. And there will also be an exercise that we'll do in breakout rooms. As public defenders, we swim in a tide of manufactured narratives. Bullshit isn't abstract, it's structural. It's the system trying to bend the past into a shape that fits the accusation, smoothing out doubt, sanding down context, reframing normal human interactions as evidence of guilt. It's the insistence that the official storyline is the default setting, that questioning it is defiance, and that advocacy is disruption instead of constitutional and moral obligation. And when I say bullshit, I mean the narrative tricks that show up everywhere. The pressure to collapse messy reality into a single prosecutorial script, the elevation of measurements and forensic outputs until they sound like destiny, not data, the 1,000 daily maneuvers, loud and small, quiet and constant, that rewrite events until guilt sounds preordained. Bullshit isn't the narrative architecture built to defend the system, not the people trapped inside it. Our job isn't to absorb it, translate it, or soften it. Our job is to expose it, to interrupt it, and to replace it with our client's reality. So I have on the screen now for you a poll. If you follow that QR code, this poll will update in real time. And my question for you is this: who's the biggest source of bullshit in your practice? Is it cops? Is it prosecutors? Is it witnesses? Is it evaluators? Is it the bench? And I'll give you a few minutes to respond. And it's really kind of fun to see that the lines change in real time. All right, and I'm just going to give you 1 more minute, and then we'll move on. All right, there's no shock here. The main source of bullshit is cops. And what you just identified here are the sources where bullshit comes from. The next step is understanding how it works across all of these sources. There are really 3 moves that I've sort of broken it down into that get used most frequently. And those moves are manipulation, spin, and false equivalence. So let's start by talking about manipulation. And specifically, I want to define what I'm talking about. It's language designed to steer perception and emotion. It's language that relabels natural and lawful behavior, This is narrative distortion at its finest. It's reshaping the facts into a justification. It can reframe a right as a failure, and once a right is framed as a failure, punishment starts to seem earned. So I want to give you an example. The defendant refused to cooperate with officers. Why this is manipulation? Does this statement actually tell you what happened? Can you picture it based on what's said here? What did our client actually do? Refused implies choice and defiance, even though nothing in the statement describes the person's actual behavior. Cooperate is undefined. It could mean anything from not answering questions to not providing consent to search, both of which are constitutional rights. And my favorite in this one, if you've heard me talk before, is the term defendant. It's dehumanizing and objectifying a real person, our client. All of this plants an emotional conclusion without providing any detail, any facts. So let's think about what the possible facts are that actually happened in this situation. Your client said, I want a lawyer. Your client stayed quiet. Your client said, I don't consent to searches. So now let's turn to see if we can come up with a client-centered alternative to the defendant refused to cooperate with officers. Mr. Elliott declined to answer questions without an attorney. Mr. Elliott did not consent to a search. So let's move on to our next category, which is spin. And I'm going to start by defining it again. Selective framing that is technically true but misleading. So spin doesn't invent facts, it sort of tilts them. The real danger here is that spin is nothing is technically false. That's the point. Spin works by selecting which facts get spotlighted and which get buried, and which get framed as inevitable or benign. Spin narrows the frame so you can stop asking better questions. It redirects attention away from power, choice, and accountability, and towards surface-level explanations that feel reasonable but are in fact incomplete. The danger of spin isn't persuasion, it's normalization. Over time, repeated spin trains us to accept conclusions without scrutiny. It teaches us what not to question, whose perspective counts, and which outcomes are presented as unavoidable. So let's go through an example of what spin is. The defendant has a history of failing to comply with court requirements. Why is this spin? Well, it's technically true in the narrowest sense. There were missed court dates, there were conditions, but it's packaged in a way that inflates the seriousness. It erases the content. It implies intent. It turns potentially minor logistical or technical issues into a character judgment. And specifically, I want to talk about these words. Using generic language like history or failing to comply, this implies a pattern with no specifics. It frames the client as choosing not to comply rather than lacking support, transportation, stability, or clarity. Notice what disappears here in this statement: time, scale, support. So let's take a minute and think about what likely actually happened here. Our client missed a court date due to transportation. They had a late check-in because of shift work. They missed treatment because they couldn't find a babysitter. Or there was a single old violation that's getting lumped into a pattern. So what is the client-centered alternative? Mr. Jacobs missed court one date last year when his bus was late. He appeared as soon as he could get more time off work. So let's move on to the third category of bullshit: false equivalence. So again, we're going to start by defining it. It's presenting unequal things as if they are equal. And the most classic example of this that I think we all run into is innocent people don't run. And so why is this a false equivalent? The statement equates running with guilt as if the two are just logically connected. That's just the way the world works. They aren't. It ignores trauma responses, fear of police, past negative experiences, racialized patterns of enforcement, lack of trust in the system, confusion, panic, or simple fight or flight responses. It collapses complex human reasons for flight into one simplistic conclusion, guilt. And it pretends this is the only possible reasonable explanation. So what would be a reasonable client-centered alternative? People run for many reasons that have nothing to do with guilt.
Yeah.
Life reflects fear, trauma, and past experience, not guilt. So now that we've sort of categorized these sort of forms of bullshit, the question becomes, how do you spot and respond to it? And so I will offer you this as a plan forward. And it's 3 questions. It's something I like to call the bullshit detector or the bullshit filter. And here's the first question. What conclusion is being stated instead of facts? What I'm asking you to do is watch for words that look like descriptions, but they aren't. They're terms like refused, history, failed to comply, uncooperative. They often show up as if they explain behavior when what they're really doing is skipping straight to a judgment without any facts to support them. Your move is to pause at this exact point the system hopes you'll glide past and ask whether the record contains the who, what, when, and how. If it doesn't, the conclusion is doing the work the facts never earned. Expose the inference, identify the unstated, and test whether it's supported by actual facts. Question 2, how does the wording make the conclusion seem reasonable? So I want you to look at the sentence and ask what's doing the heavy lifting. If the persuasive force comes from loaded verbs, character labels, or emotional implication instead of concrete detail, that's the tell. The system's most efficient move is making motive sound self-evident by embedding it, like just sticking it right into the language, and then never having to justify where they came up with it. Your move is simpler and sharper. Identify when wording is steering the reader, strip it to observable facts, and ask whether the record actually supports the implication or whether the implication is standing in for a record that doesn't exist. And the final question, question 3, is what's the client-centered alternative? Don't start with the system's inference. Start with the person's whose life is actually being described. Ask what explanation fits the facts and the human context without importing motives nobody ever proved. You don't need to solve the accusation's narrative. You need to offer an alternative that it hasn't eliminated. The power is in refusing to let the implication replace reality. Build an explanation that matches observable facts, fills gaps with reasonable inferences instead of dog whistle phrasing, and restores the person you represent to the center of their own story. So let's practice. I'm going to put up a phrase and I'm going to ask you to hop into the chat and tell me what you think and what's wrong with it, starting by what is the conclusion that isn't supported by facts. So our first phrase is the defendant was uncooperative during the investigation. So go ahead and jump in the chat and tell me, where's the conclusion here? Uncooperative, exactly. Nice, Andy. Anyone else? All right, I guess Andy's going to stand alone. Lacks observation, absolutely. All right. Lacks detail. What did he even do? That an investigation actually occurred. Absolutely. And so I think what's really telling here, and I agree, the conclusion really is that it's the uncooperative is the conclusion. And because that's not a description. There's no actual behavior that's been identified. The statement is telling us how to judge the person, not what the person did. It's missing what was asked, what was said or done, when this occurred, whether the request was lawful, whether the person had a right to decline. The bottom line is there's no conduct here, only an accusation pretending to be a fact. So let's move on to the next question for the same thing. How does this wording make the conclusion seem reasonable? And I'm going to ask you to hop in the chat again. Absolutely, Colaiuta. Use of the term investigation. I think someone else said that before too. What else, you guys? Use of legal terminology. Absolutely. Suggest the defendant chose how to act. Exactly, Cole. Absolutely. So I think the trick with this phrase a little bit, and we hear it all the time, so I think it sort of beats us down and we stop hearing it for what it is, but uncooperative sounds like somebody's making an that's objective. But it's undefined and entirely perspective dependent. During the investigation, that creates this like procedural backdrop that suggests legitimacy and authority without any kind of scrutiny. So let's move on to the third question. What's the client-centered alternative? What ideas do you guys have? Mr. Jones used his constitutional right to remain silent. Awesome. Client exercised. Oh gosh, you guys are fast and furious here. I'm having a hard time keeping up. Exercise the right to. Nice, Stephanie. Paul, Mr. Ross declined to answer questions without an attorney. I'm assuming you're saying an attorney. Client exercised their constitutional rights. Absolutely, you guys. So you don't need to prove that your client was actually cooperative. You only need to show that uncooperative is an interpretation. It's not evidence, and it shouldn't be relied on by any decision maker. So let's try another one. So the individual became increasingly confrontational as officers attempted to gain control of the situation. How many of you have seen this one? I've seen this one in the wild. So let's go through the 3 questions on this one. What conclusion is being stated without facts? Confrontational from Paul? Absolutely. Amanda, you said the same thing? Absolutely. And I see Kalea, it looks like you said situation escalated. Absolutely. All right, and I think you guys are all onto this. And it's that this whole thing implies escalation without any evidence that that's what happens. And there's no description of conduct. I love it, Cassie. What does gain control of the situation mean? Absolutely. All right, let's move on to the second question. How does the wording make the conclusion seem reasonable? Did I stump you guys? No, okay, here we go. Cole frames the officers as level-headed and trying to be reasonable. Andy, it makes it sound like the client disrupted them from doing their job. Absolutely. Cassie suggested she is being aggressive and the cops are just trying to do their job. Absolutely. You guys got all of this exactly right. attempted to gain control. It's just a presumption that control was necessary and that the officers were justified. There's no facts to support that conclusion. So finally, you guys, what's the client-centered alternative? Absolutely, Dawson. Mr. Jones questioned why the police were harassing him. Absolutely. Nicely done, Paul. Oh, everyone's afraid to follow Paul. I love it. Here we go. Dawson, awesome. Client was in the midst of a mental health crisis. Oh, shoot. And it's going fast and furious now. Confronted by officers not trained on how to deal with client specific needs. That's a great client-centered alternative. Miss Jones was confused and upset as officers tackled her to the ground. Well done, Cassie. Katrine, describe the situation from the client's perspective. Absolutely. That's exactly what we're after. What it looked like from where they were sitting or standing or being taken to the ground, escorted to the ground. All right. So we're going to move on and do a little bit more practice in breakout rooms. So you're going to be sent to a breakout room. You're going to be given 2 phrases, and I'm going to ask you guys to collectively go through the 3 questions using the BS filter. Elect someone to take notes and report out. And for the client-centered alternative, I ask you to be creative but reasonable, but recognize too that we don't have hypos for these phrases. So it is up to you to come up with what a possible other option would be. So I'm going to ask Cassie at this time to break everyone into breakout room, and we'll give you guys about 10 to 15 minutes to do that. And just for your information, in the chat, there is the list of the 3 questions, and here are the small group assignments. All right. Cassidy, do we have everybody back?
We do.
Okay, great. Well, then I will assume that you guys have elected someone to report out or voluntold them. So group 1, who is your electee?
It is me.
Hi, Kalea.
Hi.
Do you want to walk us through? You
Sure.
had, let's start with the defendant appeared agitated and evasive. Walk us through your analysis.
Okay. So we said that the terms agitated and evasive were not descriptions of actions, but rather broad strokes that did not display any of our clients' behaviors. And then that the use of the word appeared makes the assumption or conclusion seem more reasonable, because it's framed as like an opinion from an outside perspective.
Awesome.
And there's no evidence to back up the conclusions of non-compliance or any of the other conclusions that someone could make based on the sentence. And then the client-centered alternative that we had was Miss Torrey displayed behaviors consistent with mental health conditions while being detained and exercised constitutional right to remain silent without an attorney present.
Awesome. Nice job. All right, what about your second statement? The person escalated the encounter by questioning officers' directives.
Okay. This one, the use of the term escalated implies resistance or non-compliance. The vague term of officers' directives also makes the conclusion seem reasonable because the officer is then hiding under that title of officer, and the implications that what their directives were even reasonable or legal. And then the client-centered alternative is Mr. Jones asked for clarification of multiple directives being given by officers present at the scene.
Awesome. Nice work, group number 1. All right. Who is our elected volunteer from group number 2?
Hey, Angela, that's me.
Hi, Katrine. How are you?
I'm good, thank you. How are you?
Good. Well, please take it away. Your first statement was he has a long history of non-compliance.
All right. So first of all, we kind of got a little hung up on the context of this. But regardless, so first of all, we assume the conclusion is that this person is belligerent. They're intending to avoid responsibility, and they always have over a long period of time. We think that the wording makes that reasonable because of the absolutes. First of all, the long history, what the heck is that? Either long and or history, and then non-compliance being like such an absolute there as well. And so client-centered alternatives to that would be, again, depending on the context, how sophisticated was that person in whatever process that they were involved in? Did they actually understand their rights? Did they understand the requirements that were placed on them? Did these external folks explain things in a way that they could actually understand to be quote unquote compliant, showing how they made their best efforts, but factors that were outside of their control led these outside folks to assume that conclusion. But again, like looking more overall with external factors and trying to contextualize behavior rather than focusing instead on the person being deliberate or intentional and breaking whatever rules.
Awesome. Nice work. Well, you have another statement. Did you get to it? She failed to take responsibility for her actions despite clear evidence.
Right. So that's kind of similar, but so again, this also assumes that there's no other circumstances that could have controlled whatever this outcome is. It assumes the person's choosing to hide or the person has negative intent and that the person's actually guilty. And of course, the words in there like failed and clear, are just hyperbole adjectives that are thrown in there to make our clients look bad. And so and we're saying like in terms of failed to take responsibility, we were looking at more through the lens of people not admitting to what they ultimately are accused of doing. And so focusing instead on they were exercising their legal right to remain silent, to not incriminate against themselves. They were following their lawyer's advice. So they were doing what they were supposed to be doing. And then also, again, what are other circumstances that could have led to the outcome of that situation? And so again, it's maybe not all on this person's shoulders either to assume full responsibility.
Yeah, I think the thing that really gets me with this phrase is the fact that it also sort of has that feeling of like a moral failure, not just guilt. Like it's like they chose to fail. I don't know, but I think you guys really summed it up well. Well done, group two. Yay! All right, group three. Who is our volunteer elected reporter? Group three, are you there? Let's see, that was, do I have Amanda or Andy or Peter or Rebecca or Sam? Hey, Sam, how are you?
Good. I don't know how I'm getting stuck with this. I actually missed a little bit of it because I had to take a call, but I'm
Truly
here.
voluntold, huh?
Yeah.
Awesome. Well, let's give it a go. Why not, right?
Why not?
Okay, so your first phrase was she minimized her role.
What the heck does minimize mean, and what was her role? I mean, it's just assuming that she had a role in this. It's assuming that they know what her extent of her role was and that she was intentionally trying to tell them something that was less than what it was. I mean, it's at least 3 layers. It's probably 10 layers of just conclusions that are designed to do nothing besides portray your client in a poor light.
Yeah. And what about this makes it seem reasonable?
Makes it seem reasonable or unreasonable?
Reasonable.
Well, it seems reasonable because that's just the way we talk every day when you're watching some show and you see somebody come on, whether it's a politician or something like that, and they say something and you talk about them or their statement or something like that. That's how we operate as human beings, but it's just not fair to do, especially in a courtroom when somebody's on trial and you're supposed to be sticking to facts. So
Yeah.
basically, it's just letting us slip into our normal human way of how we think about things on the surface without actually handling things the way we should be, where we're diving much
Absolutely.
deeper into the actual facts and circumstances and putting aside how we usually are surface in our judgments.
Absolutely. So what's a reasonable client-centered alternative?
Well, I'm not, I was somewhat misunderstanding. Is this something where we'd be saying it or the other side is saying it? I certainly wouldn't be saying this because I
This
would
is
be
something I've seen
objecting.
in police reports when people talk often about co-defendants.
So we're talking about in a police report?
Yeah,
A lot of
potentially.
this, I was somewhat, a lot of this I'd handled through motions in limine and stuff. I see like an officer that I'm dealing with that likes to do that kind of stuff. I'm coming out with motions in limine that says that we're not going to be stating any opinions in this thing. The officer's
Absolutely.
not an expert witness. He's not going to be giving anything other than saying what his actual observations were and not conclusions on those observations, but just observations.
All right. What about the second phrase? His behavior raises concerns about community safety.
Well, again, we don't know what the behaviors are. We don't know why you're concerned. We don't know what the safety issue is. It's just three vague terms being strung together to make your client look bad.
Absolutely. Absolutely. And so what's a reasonable client-centered alternative?
A reasonable client-centered alternative is, I think, again, motions in limine. I'd be talking to that witness, and if, to the extent they're staying with that, I'd be filing something to prevent them from being able to even say anything close to that in court. But as far as trying to develop a narrative myself to deal with that, I would be coming up with something that's actually based on the facts so that the jurors have ability to see the facts that are most favorable to my client so they can make a determination for themselves of how my client acted or whether or not they were reasonable
Absolutely.
or whether or not they were a safety issue or a concern.
Well done, group three. And thank you so much,
You're
Sam, for
welcome.
jumping in and reporting out, even though you didn't sign up for that.
I
I
did not.
appreciate it. I'm sure
I just
everyone
gave
else
in.
does too.
I was just a weaker one. I gave in before the others.
Yeah, that happens. Some of us are people pleasers. Uh,
That's me.
okay, let's move on to group four. Who's our reporter?
So we were debating that when you brought us back. I'm happy to do it unless one of my
Okay.
colleagues prefers to.
Well, hi, Paul.
Hi,
How are you?
I'm good. So he failed to appear again. The implied conclusion there is that the client is a scofflaw that doesn't respect the court system. The wording seems reasonable because it's a simple 5-word declarative statement that appears value neutral. The client-centered alternative, FTA is something that happens to all of us all the time. Each one in my group came up with a perfectly reasonable explanation. Mine was Mr. Jones's phone service was suspended, so he did not receive the message from his attorney as to the next appearance date. That happens to me 4 or 5 times a month.
Very often.
But my colleagues all came up with good ones from their own experience. I mean, there's a million reasons why people FTA that have nothing to do with them being scofflaws.
Yeah. And somehow trying to pull one over on the system by doing it again.
Yeah.
Absolutely.
She was given multiple chances to comply before further actions were taken. The implied conclusion is that the quote multiple chances she was given were reasonable. Okay, that any reasonable person would have taken that. The wording, it makes it seem reasonable because again, it puts everything on her that these were conscious choices she made. My client-centered alternative, and some of my colleagues also came up with good ones, was Ms. Jones was so terrified by the hostile words and actions of the aggressive police that she froze.
Awesome. That's amazing. Well, group four, well done. Kudos to you guys. So I want to give you all a challenge. And this is something that I'm going to ask you to drop in the chat. In the chat, I want you to tell me what is one bullshit phrase you will never let slide again. interference with the administration of justice. Well done, Dawson. Defendant refused to search. Absolutely, Cassie. Well said. Well, dear question by prosecutor, how many of you would agree that police have a hard job? Absolutely, Paul. That question used to piss me off like crazy. Others? All right, well, it's one to think about. Refuse to cooperate in any form or wording. Absolutely, Savannah. Cole, anything that states my client denied the police anything from cooperation to access. Cole, that's awesome. That's a big one. All right. So I want to sort of end this on a high note. And I want to remind you guys all that nothing in the system shifts all at once, but we can shift it phrase by phrase. Every time you refuse to let a loaded statement pass as neutral, you interrupt how conclusions are manufactured. Every time you challenge the bullshit, you reshape the record, the reasoning, and the range of outcomes that become possible. That's not semantics, that's power. That's how the system actually changes. So thank you. And as always, if I can ever be helpful to you in the future, please don't hesitate to reach out. And on a final note, the handout has been put in the chat for all of you. We'll also send it to you in an email. But I'd like everybody to just give a hand to Cassidy, who none of this would be possible without. She is our operations manager for the training unit. And I thank you all, and I hope you have a great rest of your day.